The Subcommittee on Courts and Intellectual Property and the Internet will come to order with or without a gavel. Without objection, the chair is authorized to declare a recess of the committee at any time. We welcome everyone here today for a hearing on judicial transparency and ethics. And I now recognize myself for a quick opening statement. As we all know, there are three branches of government. The first branch has a key responsibility to make laws. Those laws, consistent with the Constitution, include the oversight of the other two branches. No one doubts for one moment that Congress has a responsibility to oversee Article 2, the executive branch. Oddly enough, the courts have given us explicit rulings to just that, the need for oversight, particularly the need to oversight of our appropriation, monies of the taxpayers. And yet, in many, many ways, the court, not just the Supreme Court, but all of the courts, tend to be fairly insular and seem to believe that they and they alone will determine what they and they alone shall do. Up to a point, this member would agree with them, agree that in fact interference by the executive branch or by Congress in their deliberative process, in how they go about determining what is justice, is in fact an area that we need not and should not tread upon lightly. However, when it comes to the taxation of the American people, which includes fees, when it comes to transparency, meaning American citizens and others' right to know, when it comes to the ethics of the judiciary, we have an obligation. We cannot alone simply say we'll wait to impeach a judge from time to time, about once every couple decades. The real question of whether or not judges are operating appropriately in their courtroom, not just ethically, but in fact, since it's a lifetime appointment, often we recognize that judges grow old. Judges have personal lives, and in fact, overseeing whether or not that system is properly maintained to ensure that every judge is doing and capable of doing their job when they take the bench. Additionally, today we will talk about PACER. Most Americans do not know what PACER is, but by the end of this hearing, they will understand that everything that goes on in a courtroom and then beyond, all the way through the appellate process, is made available to the public through PACER, but not necessarily for free. We all know that fees are paid when you're prosecuting a case, and judgments include court cost. What most people don't know is that the court charges 10 cents a electronic page for their records and makes a tidy profit on it, which they use in any way they see fit and in fact circumvent appropriations. That is not to say that everything they spend the money on is inappropriate or that this fund's use to ensure that we expand the ability to keep up with records is in fact inappropriate. But it does beg the question of, should the American people in this day and age receive more information more quickly and less expensively, or should we allow the court to set an amount in a vacuum that allows them to use it for areas that are often well outside of their essential needs? As I mentioned earlier, judges grow old. Alzheimer's is real. Aphasia is real. And there is no system that guarantees that a judge in his or her everyday life is in fact being properly checked to ensure that they're able to do their job, one of the most important jobs in a democracy. Today we will hear about cameras in the courtroom. There will be people on the dais for it, and there will be people against it. I will, for one, remain open-minded, recognizing that the Chief Justice is adamantly opposed to it, but that in fact there is a question of whether or not it is his right to preclude that, or it is our obligation to protect the court from becoming much like the House floor. And on each side of that argument, there will be those who speak. I think it's important today that we realize that this is the first of many hearings that will be held on the courts. And during this 2 years, I'm dedicated, in addition to the questions of the internet and questions of intellectual property, to reassert this committee's responsibility to oversee the courts, to help them do their job better, to be a conduit for what they want, and in fact, an oversight of what they do. And with that, I would like to recognize the ranking member of the subcommittee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the federal judiciary is the envy of the world. Dedicated to upholding the rule of law, our court system provides a forum for private parties to resolve their disputes peacefully and enables society to punish those who violate the law. It also safeguards our treasured liberties and ensures that the government stays within constitutional boundaries. Unfortunately, however, we cannot ignore the fact that the judiciary is under a sustained attack right now, and it is coming from what should be one of the most unlikely of places, the Oval Office. That's right, the President of the United States, whose unconstitutional Muslim ban has been rightly thwarted by the courts, has launched an unprecedented and dangerous campaign to threaten and attempt to delegitimize the judiciary and any judge who would dare enforce limits on his power. It is not uncommon for presidents of both parties to speak out against court decisions with which they disagree. But never before have we seen such a brazen attempt by a president to erode public confidence in the courts as fair and neutral arbiters of the law. As most people are aware, after Judge James Robart temporarily blocked enforcement of President Trump's immigration executive order, the president took to Twitter to label him a, quote, so-called judge, unquote. This was followed by several other tweets that attacked Judge Robart personally, called his decision political, and even claimed that if something happened to the United States, the judge and the court system should be blamed. Next, the president turned his target to the Ninth Circuit judges considering the appeal of Judge Robart's order. In a speech the morning after the court's hearing, but even before its ruling, Mr. Trump called the proceedings disgraceful, unquote, and, quote, so political, while also claiming that the judges failed to grasp concepts that even, quote, a bad high school student would understand, close quote. Then, after the Ninth Circuit left Judge Robart's order in place, one of President Trump's top advisors, Stephen Miller, said, quote, the judiciary is not supreme, unquote, and challenged the court's legitimacy to question the president's interpretation of the law. Finally, the president summed up his thoughts on Twitter this weekend, writing, our legal system is broken. I beg to differ. I think our court system worked exactly as it is supposed to. As chaos and confusion reigned at our nation's airports, the court stepped in to clarify that no one is above the law and that the Constitution still provides certain fundamental protections. Although the drama surrounding President Trump's executive order has been temporarily set aside, we must not become complacent in the face of such attacks on the integrity and legitimacy of individual judges or of the court system generally. Especially when they come from the President of the United States, such attacks are both inappropriate and reckless and dangerous. Already there have been reports that judges involved in legal challenges to the executive order have been threatened and require increased security protection. Moreover, President Trump's broadsides against the federal courts threaten to undermine public confidence in the institution of the judiciary itself. An independent judiciary is fundamental to the checks and balances that are embodied in the separation of powers and is essential to maintaining liberty and the rule of law. I am disturbed that the President either does not appreciate the role that an independent judiciary plays in our constitutional system or does appreciate it and seeks to undermine it. I hope that my Republican colleagues, especially on this committee, will join me in demanding that the President cease these attacks on the judiciary immediately. My deep respect for the judiciary does not mean, of course, that there are no improvements that we can make to the court system, particularly when it comes to transparency. This includes stronger ethics and disclosure requirements, particularly with respect to the Supreme Court, which is not bound by the Code of Ethics that applies to other federal judges. Another important transparency measure would be televising judicial proceedings, at least in the appellate courts. I know that the Judicial Conference has undertaken a pilot project to bring cameras to the courtroom but I think it is time to expand this across the federal appellate courts. I recognize there are privacy concerns when it comes to trial court proceedings, but there is no reason to shield appellate courts from public view. Public scrutiny of governmental proceedings and an informed citizenry is essential to democracy. But most courts are closed to cameras, effectively putting them off limits to the public at large. Transcripts and audio recordings, some of which are made public days, or in some weeks, even weeks later, are poor substitutes for the immediate visual experience. That is why yesterday I reintroduced the bipartisan Eyes on the Courts Act. This legislation would finally bring important cases into public view by requiring that cameras be allowed in all Supreme Court and federal appellate court proceedings. I do not share the concerns of those who believe that the highly trained lawyers and judges in appellate court proceedings tackling some of the most important issues facing our country will start playing to the cameras. Nor am I aware of any such problems occurring in those federal courts where cameras have been used. The nation was riveted by the live audio stream of the Ninth Circuit's consideration of the President's executive order last week. Clearly, there is great interest in wider access to court proceedings, and I see no reason the public should be prevented from witnessing the other important cases considered in the federal appellate courts. I respect the difficult and important job that the federal judiciary performs. If my bill becomes law, the public will have an opportunity to watch them in action and to gain a greater understanding and appreciation of their critical work. I look forward to hearing from our witnesses on this issue and on other important topics affecting the federal judiciary, and I yield back the balance of my time.
I thank the gentleman. We now recognize the chairman of the full committee, the gentleman from Virginia, Mr. Goodlatte, for his opening statement.
Thank you, Mr. Chairman. This morning, the Judiciary Committee continues its examination of our nation's, we have a brief delay here. Excuse me. This morning, the Judiciary Committee continues its examination of our nation's federal judicial system. It's widely recognized that the trust that the American people have in our court system is crucial to its success. While this trust has been cultivated over many generations, it can be quickly lost. This is why it is important that the judiciary continue to operate in a transparent manner at all times and handle the disputes before it efficiently, ethically, and impartially. This morning, we will hear from 3 witnesses who will present their ideas regarding ways to increase judicial transparency and accountability. These suggestions include greater use of audio and video recordings in courtrooms, free or lower cost access to court documents through the PACER system or potential replacements for it, and public disclosure of recusal decisions. Other issues we will consider today are the judicial disability and disciplinary processes. Decisions made by judges with undiagnosed medical conditions can be subject to challenge years later. It is crucial that all judges have the resources and confidential programs needed to assist them if they have any questions about their fitness to serve. Regarding judicial discipline, there have been relatively few impeachments of federal judges by the House of Representatives. The federal judiciary has its own internal disciplinary system that, in theory, addresses misconduct before the conduct escalates to the level where impeachment would be warranted. However, many members of Congress have questions about the judiciary's disciplinary system. Today, we will explore this system further, including examining the remedies available for judicial misconduct, their application, and the constitutional and other limitations on those remedies. I want to thank our witnesses for making time available to be here in order to provide testimony for improving our nation's judiciary. Mr. Chairman, I yield back.
I thank the gentleman. It's now my pleasure to recognize the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Issa. Welcome to all our witnesses. Today's hearing gives us an important opportunity to examine judicial transparency and ethics issues. But I'd like to begin my remarks by addressing some of the troubling statements President Trump has made about judges and the judiciary. Earlier this month, the president disparagingly referred to a member of the federal bench as a so-called judge and criticized his decision as ridiculous. This judge is now in receipt of death threats. And last year, while campaigning for the presidency, he called into question the validity of a ruling by a federal judge because of the judge's ethnic background. Most recently, President Trump, in opposing a decision rendered by the Ninth Circuit said even a bad high school student could understand that his immigration ban was authorized by law and that it was a political decision. President Trump's personal attacks against individual judges, as well as disrespectful comments regarding the federal judiciary as a whole, threatened the fundamental principles of our constitutional form of government, namely respect for the rule of law and an independent judiciary. Even his Supreme Court nominee, Neil Gorsuch, characterized President Trump's comments about the judiciary as disheartening and demoralizing. Respect for the federal judiciary should be a nonpartisan issue, and this hearing is an example, an excellent example, I might add, of cooperation with respect to oversight of that branch. Yet, we must also be mindful of the potentially destructive attacks against the federal judiciary, even if those attacks emanate from the executive office of the president. Accordingly, I hope my friends on the other side of the aisle will join me today in condemning President Trump's comments threatening the legitimacy of our judicial branch and efforts to cast aspersions against individual federal judges. An independent judiciary is critical, of course, to our nation's constitutional system of checks and balances. And we should do everything possible to ensure that that system is not undermined. As to the additional areas that we will consider today, I do support having cameras in the courtroom, but continue to believe their impact must be more carefully considered. The Judicial Conference, for example, notes that cameras in the courtroom could potentially impair the fundamental right of a citizen to a fair and impartial trial. And Justice Elena Kagan warns that televised coverage of federal court proceedings would encourage participants to play to the camera. I'd like to hear proponents of cameras in the courtroom explain how those efforts will neither undermine a citizen's right to due process and a fair trial, nor have a material effect on an individual's willingness to testify out of fear of being a target for retribution or intimidation. Finally, I support increased transparency of the judiciary. Last week, the Ninth Circuit Court of Appeals provided live stream coverage of the oral argument on the administration's appeal of the lower court's imposition of a nationwide stay of President Trump's immigration order. Efforts such as these by the federal judiciary, which makes their processes more readily available to the public, will promote even greater respect and understanding of the federal court system and the rule of law. And as we promote transparency, we must also be mindful of the need to ensure the safety and security of our judges, law enforcement officers, and others participating in the judicial process. I thank and applaud the chairman for holding this hearing, and I yield back the balance of my time.
I thank the gentleman. I now, without objection, other members' opening statements will be made in the record. Today we have a distinguished panel of witnesses whose written statements have been entered into the record, and without objection, all your written statements and extraneous material will be admitted to the record. Without objection, so ordered. But today I would ask that you summarize your opening statements in about 5 minutes. To help stay within the timing, you know the lights, you've all been here before. Please, green means go, yellow means you got a minute, and red means you'll get a ticket if you run the light. Before introducing our witnesses, it is the rule of the committee that all witnesses be sworn, so I would ask that you please rise to take the oath. And raise your right hands. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Let the record indicate that all witnesses answered in the affirmative. Our witnesses today include Mr. Mickey Osterreicher. More importantly, the General Counsel for the National Press Photographers Association, who, needless to say, have been giving us images of the courts for more or less a century. Professor Thomas Bruce is the co-founder and director of the Legal Information Institute at Cornell University. Welcome. And Professor Charles Jay is professor at Indiana University, Moyer School of Law, and each comes with a level of expertise to help guide us through three different areas that we're going to look at today. So welcome. You're recognized for 5 minutes.
Chairman Issa, Ranking Member Conyers, Ranking Member Nadler, and other members of the subcommittee, good morning, and thank you for the opportunity to appear here today. My name is Mickey Osterreicher. I am of counsel to the law firm of Barkley and Damon, and I'm here today in my capacity as General Counsel for the National Press Photographers Association, an organization which was founded in 1946 and of which I have been a member since 1973. As the voice of visual journalists, the NPPA vigorously promotes and defends the rights of photographers and journalists, including intellectual property rights and freedom of speech in all its forms, especially as it relates to visual journalism. By way of background, I am an award-winning visual journalist with over 40 years' experience in print and broadcast. During that career, I have covered hundreds of court cases, from the Attica trials to the murder trial of O.J. Simpson. I was actively involved in the New York State experiment between 1987 and 97, entitled Electronic Coverage of Judicial Proceedings. And by electronic, I mean audio-visual recordings, still photography, broadcasting, televising, or internet streaming, both in real time or hyperlinked replay. In an era of fake news and alternative facts, there is no better way to ensure transparency and promote confidence in the fair administration of justice than to expand electronic coverage of federal court proceedings. Transparent court proceedings improve the quality of testimony, persuade unknown witnesses to come forward, make trial participants more conscientious, and provide the opportunity to better observe the workings of our judicial system. To foster that essential principle, almost every state allows electronic coverage of criminal, civil, and appellate proceedings to some degree. For many years, Congress has proposed legislation to allow such coverage, most recently by Representative Connolly and Judge Poe. Representative Nadler also introduced the bill in 2015, which he just reintroduced. The NPPA commends and supports these ongoing efforts. More recently, there have been some advances and some lost opportunities in this area. For example, the Ninth Circuit began live streaming audio of oral arguments in 2015, and the Second Circuit continues its policy of permitting electronic coverage for cases with heightened interest. By comparison, the Supreme Court has released same-day audio of an oral argument only once, despite numerous requests to do so. In 2015, it denied such a petition for two of the year's most important cases. The last federal cameras pilot program officially ended in 2015, and while the Judicial Conference voted against expanding or continuing that project, it did permit 3 of the participating trial court programs in the Ninth Circuit to remain operational. Just this month, electronic coverage was allowed in state of Washington v. Trump, which was recorded and uploaded to the court's website. Last week, the telephonic arguments of the appeal in that case were heard live, with approximately 137,000 connections to the audio stream from the court's YouTube site. CNN, which also broadcast the arguments, averaged 1.5 million total viewers during that hour. Millions more may have tuned in on cable news outlets, local news stations, and countless other news websites. These latest developments weigh strongly in favor of electronic coverage and should also prompt the Judicial Conference, along with the High Court itself, to finally promulgate common-sense guidelines permanently allowing such access through the federal court system, up to and including the U.S. Supreme Court. Justice Stewart noted in 1965, "We move in an area touching the realm of free communication. And for that reason, if for no other, I would be wary of imposing any per se rule which, in light of future technology, may serve to stifle or abridge true First Amendment rights." The framers envisioned court as being part of a public square, a place in an emerging nation where anyone could stop in to observe the proceedings and be assured of the integrity of our system of justice. Given the increasing complexity of our society and the size of our communities, that aspiration is exceedingly more difficult to achieve. As Chief Justice Berger stated in a 1980 case, people in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. The ability of the public to view actual courtroom proceedings should not be trivialized. It touches on an important right, which goes well beyond the mere satisfaction of viewer curiosity. That right, advanced by electronic coverage, is the right of the people to monitor the official functions of their government, including that of the judiciary. Nothing is more fundamental to our democratic system of governance. The NPPA looks forward to working with you on these issues and thanks you for the opportunity to testify. I welcome your questions.
Thank you, Professor Bruce.
Chairman Issa, Ranking Member Conyers.
If you could pull the mic slightly closer, I'd appreciate it. Thank you.
Chairman Issa, Ranking Member Nadler, Ranking Member Conyers, members of the committee, thank you for inviting me to appear before you today. My name is Tom Bruce. I am the director of the Legal Information Institute at Cornell. We have been putting legal information online for the public for 25 years and currently reach an audience of approximately 32 million individuals each year. I'm here to talk to you today about the operation and future direction of the PACER system for public access to the opinions of the federal courts. Let me begin with three things that define PACER. First, PACER charges fees for access to public records. That has been the cause of a great deal of criticism, not only because fees erect a barrier for many, but because the revenue from fees at current levels considerably exceeds the cost of operating the system. That is inconsistent with policies established by the Congress in the E-Government Act of 2002. Second, PACER's technology has struggled to stay up to date. That was, to some extent, an accident of history. PACER was implemented shortly before the introduction of the World Wide Web, and it was all too quickly seen as outmoded and out of touch with current technology. Over the last few years, it's made up some of the gap, but the system still falls short on a number of dimensions, notably in the area of search and retrieval. Third, and most important, PACER suffers from a split personality. On the one hand, it's an electronic filing and case management system that supports the federal courts with an audience of lawyers, judges, and court administrative personnel. On the other, and most important to the public and the Congress, it's a data publishing system that offers the work of the federal courts to a very wide range of people, including litigants, researchers, and government itself. Equally, there are a number of things that PACER is not. First, PACER is not transparent in its business model or operations. Second, PACER is not an adequate facility for research on the activities of federal courts. That's chiefly because it does not provide bulk access to its data. Significantly, research activities that might be carried out on behalf of the Congress are impeded. Social Security cases, prisoner appeals, and immigration matters are all examples of areas in which study of judicial outcomes is important to those who have responsibility for investigation and evaluation of operations across the full breadth of the government. Third, PACER is not an effective protector of privacy. And finally, it's not an adequate vehicle for citable legal research because it lacks a system of unique identifiers. These are hard problems, especially given the scale and diversity of what's published in PACER, but they are soluble provided that Congress acts. Both the Congress and the federal courts have strongly and repeatedly announced their commitment to providing full access even to unpublished opinions at minimal or no cost. So what needs to be done? First, fees need to be removed as quickly as possible. Dissemination fees have strongly inhibited beneficial uses of the data contained in the primary record of the workings of our federal courts. Consideration should be given to removing per-page viewing fees, or at the very least, paring them back to a level that more closely matches PACER's cost of operation. Second, the details of PACER's operations and business model need to be far more visible to the Congress and to the public. A CRS report describing the business and technical operation of the system in detail would be more than helpful and would bring welcome clarity to many of the issues involved. Third, the users of PACER's data publication services need representation in the planning and design processes. Published articles by PACER's designers celebrate the responsiveness of its design to the needs of users of the e-filing and case management systems. That can be charitably interpreted as a sound effort to respond to a range of important customers who are in a position to express their needs to the designers. Understandably, those to whom the designers answer are preoccupied with the e-filing and case management portions of the system and are not nearly as concerned with publication. Fourth, PACER's data publishing operation should move to a new home. Why not put responsibility for data publishing operations with an organization that has publishing as its primary mission? The Government Publishing Office and the AO already have a pilot program for the publication of judicial opinions underway. It's been successful. It appears to be scalable to the dimensions that PACER would require. Much work would still be needed. GPO's system only extends right now to about 100 courts. Its chronological range is narrow, and better metadata is needed even within PACER itself. But the potential benefits are many. First and foremost will be the removal of barriers that prevent the public from exercising the right to know the laws that govern them. Publication systems that permit research utilizing the full range of data available from PACER will make it easier for the Congress to fulfill its responsibilities, improve the efficiency and functioning of the judiciary, and stimulate new approaches to legal information while encouraging new and innovative businesses. Thank you for the opportunity to testify today. I look forward to your questions.
Thank you. Professor Jay.
Mr. Chairman, it's a privilege to appear before the subcommittee. I served.
Perhaps the microphone a little closer and on. Yes.
There we go. Maybe if I turn it on, it works better.
Superb.
It's a privilege to appear before the subcommittee that I served as counsel nearly 25 years ago. Dry gulp. The Constitution works, and the judiciary it established works because we believe it works. If we lose that faith in the judicial system, Congress can gut its budget, the president can defy its orders, and the role the framers envisioned for the judiciary keeping the other branches in check will be lost. And so I do share Mr. Nadler and Mr. Conyers' concern that there's a difference between robust criticism, which I think we need, it's essential to accountability, and assaults on the legitimacy of the judiciary as an institution, which do worry me, because the judiciary is fragile in that regard. Unlike Congress, which derives their legitimacy from the voters, the judiciary doesn't have voters. They derive it from their perceived integrity, their perceived impartiality, their perceived independence, which really is the subject of this hearing today. Because the mechanisms like recusal, like discipline, like codes of conduct, like disclosure, are ways that we hold the judiciary accountable. They're the ways that we hold the judiciary, make sure that the judiciary is legitimate. To those ends, let me talk first briefly about disqualification. I think the substantive standards are fine. I think that there's a concern, though, with process. Congress has not legislated the process for disqualification, which means that it's all over the map. And the norm that worries me most is the norm that judges get to decide their own disqualification, which is like grading your own homework. I think it's problematic from an appearance standpoint for judges to be put in the position of being asked, are you too partial to sit? And the person who answers that is the judge who may be too partial to sit. I think we need to work on that one. Second, when it comes to codes of conduct, the Judicial Conference promulgated codes beginning in 1973, and they're terrific. Unfortunately, the Supreme Court does not have a code that applies to it either. And I think that is a problem. 25,000 judges in the United States, 9 are not subject to a code of ethics, and they're the most powerful judges in the country. The optics are bad. Now, the Chief Justice tells us that they don't need a code because they consult the code that applies to the lower federal courts. The trouble with that is that you know and I know that you're going to react differently to a code that applies to someone else as opposed to a body of rules that applies to you, and the Exhibit A for that would be Justice Ginsburg from last fall, when she starts criticizing then candidate Donald Trump under circumstances in which the code of conduct says, no, you don't. 2 days later, she retracts those statements after the code is called to her attention. I'd like to think that if they had a code and bound themselves to it, this problem would never have occurred. Turning to discipline, the disciplinary process has been in place since Congress created it in 1980. It did fall into some disrepair about 10 years ago, and thanks to the vigilance of this committee, the process got jump-started, and I would like to congratulate the Judicial Conference for making some significant improvements in 2008 and again in 2015 that have made it work better. My lingering concern, frankly, is that with the disciplinary process is that, it is, under the statute, the statutory standard is exceedingly vague. Misconduct is defined with reference to conduct is prejudicial to the effective and expeditious administration of the business of the courts. I worry a little bit that lets the judiciary do whatever they want to, and that's too strong. I think they do a conscientious job, but the trouble is that from a perception standpoint, that can mean just about anything. The solution that virtually every state has employed is to say, we can have this general disciplinary standard, but we define it with reference to the code of conduct. Has the judge violated the code of conduct? If so, then is the violation severe enough to warrant discipline? But by tethering this very vague standard to the code, everybody understands what the operative rules are and when a judge is going to be at risk. Finally, I didn't talk about this at length in my testimony, in my written testimony, but a point about disclosure. I think that the financial disclosure statements are essential for the general public. They're essential for lawyers who have clients who appear before judges, and they're essential for watchdog organizations. My concern is that we still don't have a system in place where we are enabling the public to get ready and open access online to those disclosure statements. I understand where the judiciary is concerned, and I suspect the judiciary's primary concern is for the safety and security of its judges. There are nasty people out there who appear before judges, and they worry that information about the judge's family and addresses can be problematic. That, I think, is best resolved by redaction rules and not by hiding the ball when it comes to forms that the public is legitimately entitled to receive. Thank you.
Thank all three of you. I'll now recognize myself for a round of questioning, and I'd like to ask unanimous consent that the statement by Professor Jonathan Zittrain be placed in the record, in which essentially he offers to make available PACER for free. And I'll begin there. Professor Bruce, is that viable? Is it viable to simply offload all of the information of the courts potentially to make it free without commercial advertising?
It's very difficult to tell, and that's part of the reason that I am interested in getting more detailed reporting of PACER's finances. And people have made various suggestions over the years. There is some thought that, for example, the entire cost of covering PACER could be generated through filing fees. There's also the possibility that one could go into some form of commercial licensing for those who are actually making commercial use of the data as another possible source of revenue. But all of those at this point are merely informed guesses because the finances of PACER are not particularly transparent. I received this morning, as you have, a bunch of information about PACER's financials that I have not seen before. As far as operating from a third-party point of view, if someone were to hand that to us tomorrow, it would be difficult to do. I do think that the people who are operating FDSIS at the Government Publishing Office are in a good position to do it. They are a quarter of the way there already in terms of the number of courts that they're covering.
Thank you. Now we go to cameras in the courtroom. Mr. Ostreicher, let me move away from cameras in the courtroom directly and just go around to quick questioning for my own edification. Is it reasonable to assume that since the courts in most areas of the country allow witnesses to be video deposed, and those depositions are in video form are admissible, that in fact video has a practical value to juries making decisions?
I think it absolutely does. Part of a jury's function is to look at the demeanor, character of those people testifying. Sometimes just seeing a transcript or even just hearing the audio is not enough. So I think that video is a very important component. I also think even though most court proceedings are not very compelling television, if you have high quality
But you've been there for the good ones.
yes. But even then, sometimes, you know, it's been said that most courtroom proceedings are like watching paint dry. It just is not the Perry Mason confession moments that we're used to seeing in an hour's worth of television. But that said, I think they're far more interesting than just the transcripts and audio themselves, though in the alternative, as we've seen just recently, there were a lot of people that wanted to hear that oral argument in the Ninth Circuit.
Yeah, that's one thing we can count on is even when paint's drying, somebody will dump the bucket every once in a while. It'll get very exciting in the room. Professor Jay, I want to spend the rest of my time asking a few questions on ethics. You mentioned conflicts of interest, and this is a great question. Do you believe that we have the obligation to ensure that a system is in place that is verifiable as to people who have conflicts, and thus there has to be disclosure in order to determine whether there may be a hidden conflict?
I'd agree.
Do you believe that at a minimum, a body in camera must make that decision? And when I say in camera, obviously you talked about redacting, but however it's done, it has to be sufficient to understand where the conflicts may come, while in fact protecting the privacy, necessary privacy of judges.
Right, and I would defer, there's a Judicial Conference Committee on Financial Disclosures that I assume would be able to help with that, but yes.
Now currently, each circuit is the highest authority for whether a judge is competent, isn't that correct?
Competent to, in terms of having a conflict?
No, if a judge becomes unable
Disabled,
to...
the disability provisions.
Yeah, under disability, it's
The
decided
circuits
at the
control
circuit.
that.
And constitutionally, what basis is there for a circuit to decide it when, in fact, the Constitution only gives authority to the Supreme Court?
What's the constitutional authority for the legislation that provides for that, you mean?
Well, what's the constitutional basis for putting it at a circuit rather than holding some level of responsibility? In other words, have we written statutes that negate the ultimate responsibility of 9 men and women on the court?
Well, if we're talking about the competence issue, I think that, the way I look at it is the 1980 legislation provided for a circuit-based disciplinary and competence standard that dates back to 1939.
Okay, and I'll be brief with the last two quick questions. One, currently there's no transparency as to that. In other words, you really don't know whether somebody's being considered for either their technical competence, their health competence, or their ethical competence.
In the early stages of the process, it is not. That's right.
And lastly, currently there's no requirement for physical or mental evaluations of judges even into their 70s, 80s, and 90s.
Not that I'm aware of.
Thank you. I now recognize the ranking member for his questions.
Thank you, Mr. Chairman. I have several questions. Before I ask them, I ask unanimous consent that a statement from our colleague, Mr. Connolly of Virginia, be entered into the record regarding his legislation, the Cameras in the Courtroom Act, which would require television coverage of the Supreme Court, along with a copy of the bill.
Without objection, so ordered, and we will not take that as an endorsement of the alternate legislation, I trust.
No. Just as a reference. Thank you. Mr. Osterreicher, it's been estimated that between the live stream on YouTube, Facebook Live, and simulcast on the cable networks, more than 1 million people tuned in to listen to the Ninth Circuit's oral arguments in the executive order case. Do you think that the ability to listen to the arguments without any news filter helped people counter the president's assertions or judge the validity of the president's assertions about the integrity of those proceedings?
I think it's critical that people, as I said, in this day and age of alternative facts and accusations of fake news against the media, that the people have an opportunity to see and hear from them for themselves how government is conducted in all three branches. Unfortunately, what we've seen is in the judicial branch, that has not always been available, at least at the federal level.
Well, here it wasn't the media's characterization, it was the president's characterization of the hearing as terrible and horrible and so forth. And do you think that the fact that over 1 million people at least heard the audio stream helped counter that?
It's a much more direct form of democracy where people can see and hear for themselves, just as our framers envisioned, being able to, stop by court on their way about their daily activities. Unfortunately, these days that can't happen, but we do have the capability of that type of communication through audiovisual coverage.
Thank you. Now, the argument before the Ninth Circuit was a very high-profile case, obviously. And on rare occasions, the Supreme Court has released audio of high-profile cases within minutes of the argument's completion instead of at the end of the week, as is the normal practice. Is there any rational distinction between how the Supreme Court handles high-profile cases and how it handles less newsworthy cases?
I don't think that there should be. I think that they should develop some standard practices. In terms of releasing, they've only done that once. Most of the time, even in high-profile cases, in the 2 that I mentioned last year, they still said that in a very terse statement, they would stand by their Friday release. And as most people know, Friday is not exactly the best day to get people's attention when they're trying to start their weekend.
It's dump day, but is there any rational distinction between the cases, other than that they were high profile, where the Supreme Court released the video, the audio transcript quickly, and most cases where they didn't?
I don't think that there really should be. Again, I think...
Should be, but is there a rational distinction that you can make that said, well, here the Supreme Court said yes, but there they said no for the following reason?
No.
There's no rational distinction here.
Not as far as I can see.
When the Supreme Court has released audio more quickly, have you witnessed any ill effects?
No. I mean, it's an appellate review, so we're not looking at somebody's Sixth Amendment rights coming into play as we might in a trial court.
That's why my bill doesn't include trial courts.
I understand.
One of the criticisms of bringing cameras into the courtroom that we hear most often is that the lawyers or judges may play to the cameras. Are you aware that this has occurred in any of the courts that participated in the Judicial Conference's pilot program?
Not that I'm aware of, and as a matter of fact, in that 10-year experiment in New York, I think the most telling statistic is the fact in the tens, if not hundreds of thousands of cases that were heard, not one appeal was taken in a criminal court case or in any case based on the fact that someone didn't get a fair trial under the Sixth Amendment because of the fact that there was a camera in the court.
In those trials, in that trial situation, I suppose you'd have to call it, are you aware of any allegations by anyone that any hearing was affected by playing to the cameras?
No, there's always been that speculation, but
Speculation. Any allegation that in that case this is what happened?
none that I'm aware of.
Thank you. And Mr. Bruce, you have given a lot of careful thought to various ways that you believe PACER could be improved, both from a technical standpoint and ways to enhance public access to the documents contained in PACER. Have you had the opportunity to share your views with the Administrative Office of the Courts?
No, I have not, sir.
Oh. I was going to ask if they were receptive to your recommendations, but obviously you haven't shared it with them. Have you asked for the ability to share it with them?
I have not.
Is there a reason for that, or?
I am, to be honest with you, sir, fairly new to the issue. I have monitored it for years. It has not been something to which I have paid deep attention until recently.
And finally, what sort of ability does the public have to comment on PACER, if any?
None that I'm aware of.
Thank you. I yield back.
I thank the gentleman. We now recognize the chairman of the full committee, the gentleman from Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman. Mr. Jay, in cases of alleged misconduct, this committee has deferred to the Judiciary Committee in some instances for an initial investigation before its potential referral to us for further action, including the possibility of impeachment. Does the judicial branch operate in an efficient manner when it's conducting its investigations?
Much more so. I think that this committee lit a fire under the judiciary about 10, 15 years ago when this committee reached the point of actually considering the impeachment of Judge Rial. And part of it was to say, look, if you're not going to do your job, we're going to have to take in. And that, I think, resulted in some very positive things, including some upgrades to the judicial disciplinary process. I now feel as though they are taking it seriously. I think that this kind of oversight is critical to maintain that. But yes, I do think that they're doing a much better job than they were if I were testifying 15 years ago.
I generally agree with that. I've had experience handling 2 impeachments of federal district court judges. In one of those instances, I'm not sure that the committee would have had the wherewithal to proceed without the preliminary investigative work that was done by the, I believe in that case it was the Fifth Circuit Court of Appeals. The Justice Department declined to prosecute in that case, and it left us in a situation where we really had to develop our own case. We had 4 articles of impeachment. In the end, the Senate voted to convict that judge in all 4 instances, and I would give a lot of credit to the work that was initially done by the Fifth Circuit to lay the groundwork and provide information to us that was the foundation for our building case. However, I also recall that in that case, there were a number of judges that did not believe that the offenses that had been committed by that judge were indeed impeachable offenses. And so I'm wondering if this process, the way it is laid out today, puts the judiciary in an awkward situation where people who work with each other on a regular basis are called upon to pass judgment upon those same members of that same circuit of the judiciary. And I wonder if you have any observations about that.
Well, I'm not sure if you're talking about Judge Porteous.
I am talking about Judge Porteous.
I was an expert witness for the prosecution in that case. I differentiate in my own mind between conduct that judges may think is bad behavior warranting discipline and conduct that is so bad that it warrants impeachment. And I felt as though that was an example of the system working as it should because they worked it through the pipeline and ultimately recommended that impeachment be taken. The Real case that I talked about before is more of a case where I think it was dysfunctional because then the system ground out for years in the disciplinary phase without the public having adequate notice. I do think what you're calling attention to is the inherent problem of judges judging their own. And that is an inherent problem. And to my way of thinking, the way we address that problem best is by keeping feet to the fire in a limited way by basically having hearings like this in which we bring the judges forward and say, what is the process? How does it work? Tell us how it works, and whether we're getting adequate transparency at what points in the process so that we can look at it and say, this is good. The last point I'll make is that Congress abandoned meaningful impeachment investigation in the 1940s because it's bloody exhausting. That they waited for someone else, either a prosecution or the judicial, to go first. I think that's preferable, given how much work this body has, if we can manage to make that doable.
I take it then, however, that you think we should have another panel or another hearing in which we invite judges themselves to come and talk about these same issues.
I think so. I think that's important, yeah.
Addressing here today, and I agree with you. Mr. Oestreicher, some have expressed concern about sensitive information being made public if cameras are allowed into the courtroom. How can sensitive information best be protected when cameras are present?
I think that every legislation that I've seen really relies on the discretion of the trial court judge. He or she should be the final arbiter as to what happens in his or her courtroom. At the appellate level, I think, there's a number in all the briefings. If something needs to be redacted, that's fine. But I can't imagine during an oral argument at the appellate level that we would see that sensitive information. So at the trial court level, once again, I think that should be in the discretion of the presiding judge.
Would the gentleman yield for a second?
Yeah, I'd be happy to yield.
But and in any event, if that problem exists with the audio, which is released now. The camera doesn't really add or detract from that problem.
I thank the gentleman for his comments. I thank the witness, and I yield back.
I thank the gentleman, and we now go to the gentleman from Michigan, Mr. Conyers.
Thank you so much. I want to go back to the cameras in the courtroom for just a minute. Some believe that cameras in the courtroom could heighten the level of and the potential threats to federal judges, particularly those proceedings involving highly controversial matters. Mr. Osterreicher, how do you feel about that?
Well, I think it's very difficult to put the genie back in the bottle. As we've seen from the internet, if you do a search, you can usually find somebody's image with their name. The last time that I testified before the subcommittee, that issue was raised as well by the federal trial court judge who was also one of the witnesses. I had never seen her before, but was able to, once again, Google her name and come up with lots of images of her. So the fact is that if somebody's testifying in court, that their image will be shown. I think I certainly understand the concerns of the jurists there, but again, in terms of the presiding justice, if there is a security issue with one of the witnesses, then that judge has the ability to decide that that video not be recorded or broadcast.
Professor Jay, in your testimony, you state that there are 25,000 judicial officers in the United States, all but 9 of whom, the most visible and influential 9 in the nation, are not subject to a code of judicial conduct. Should Congress consider legislation that requires the Supreme Court to promulgate a code of conduct applicable to itself?
I think so. Steve Gillers and I wrote an op-ed last year in support of Mr. Murphy's bill that did just that. And you know, in a perfect world, the judiciary would quietly appoint a committee and promulgate a code of its own based on the code of conduct for U.S. judges, but it hasn't done that. And I do think that if we're concerned about the legitimacy of the judiciary, we really ought to think seriously about insisting that they take that step.
And let me add this. Is it possible that President Trump's recent statements about the judiciary could cause citizens to lose faith in the rule of law and the judiciary? And why would that be a huge problem if that's so?
In my view, sustained attacks, not in the form of criticism of judicial decisions, not in the form of criticism of judges, but suggesting that the judiciary should not be respected because the judges are so called because they are only deserving of respect if they do what the president wants. Over the long term, that can erode public confidence in the independent judiciary. And let me just say that I'm not a social scientist, but I follow a lot of social science about this, and the social scientists have drawn a line between talking about the courts as legal realists, where they're influenced by their ideologies and so forth. The public understands that. 90% of the public is cool with that. They understand how that works. It doesn't cause them to think twice about the legitimacy of the courts. The line gets crossed when they are perceived as just politicians in robes. In other words, not just that these are honorable people who may be influenced by their backgrounds and experience, but they're politicians in robes. And the concern I have is when you're calling them just political, when you're saying they're so-called, when you're calling them disgraceful, is that you run that risk. And at that point, I think you can very quickly, the judiciary can fall like a house of cards if we lose that legitimacy.
Thank you so much. Is it possible then that President Trump's recent statements about the judiciary could cause citizens to lose faith in the rule of law and the judiciary?
I would like to think that the American people are made of sterner stuff in the sense that if this persists, we have a serious problem. My hope is that that essentially the response to those attacks creates a public debate that allows for this problem to be neutralized. So I join conservative scholar Will Bode, who was in the Washington Post last week, in saying these attacks are deadly serious. By themselves, I'm not sure that they are going to diminish the legitimacy of the judiciary, but if gone unresponded to or uncorrected, they could.
My final question is to Director Bruce. What barriers should be removed that prevent the public from reading the opinions opinions of the court in your estimation?
The first and most important barrier is economic. It's the per page viewing fee. The second is a problem of sort of practical obscurity that has to do with the data in the system. So, for example, in PACER currently, it's actually not possible to retrieve with any certainty the author of a specific opinion. In other words, if you want to see all the opinions by Judge Smith, that cannot be done with complete confidence. And there are other metadata lacks we could point at, but that's the most striking one.
Thank you so much. Thank you, Mr. Chairman.
I thank the gentleman. We now go to the gentleman from Pennsylvania, Mr. Marino.
Thank you, Mr. Chairman. Welcome, gentlemen. I'm going to get directly to the issue. Do any of you support cameras in the courtroom other than appellate arguments? And start with you, Mr. Jay.
I support it only in appellate arguments. I support it in limited use in trial scenarios, carefully circumscribed to protect litigant rights.
Professor Burns?
I agree with Professor Jay.
Okay. Sir?
I support them in all aspects of the judicial proceedings. For all these years, all of the concerns that have been expressed have been shown to just be speculative. The last time the Supreme Court heard a case based on the fact that somebody claimed they didn't get a fair trial due to cameras was 1981 in Florida v. Chandler. So I think, again, under the discretion of the trial court judge, that cameras are absolutely crucial to allow the public to see what goes on in courtrooms.
But sir, don't you think that speculation is something that really should not play a part in this, particularly in a criminal proceedings, in a capital murder case, for the person, the defendant, for the family members who are sitting there because of the victim? Anything that we can prevent from swaying a decision other than the facts before the jury, I think is most paramount. You have a response?
I believe, having been in courtrooms throughout that 10-year period and beyond, that the jury, the participants, are completely unaware of the fact that there are cameras. And that was when there were actual personnel in the courtrooms. Now we have multiple cameras in this room. I think for the most part, eventually people get used to the fact that they're there. We're videotaped and photographed dozens, if not
Don't you
scores
think
of
that
times
a witness, particularly a child, would have reservations about testifying in front of a camera? Don't you think that, look, there's enough grandstanding in Congress before the cameras, in hearings and on the floor. Can you imagine what would take place in a courtroom?
Well, I kind of saw what took place in the courtroom during the O.J. Simpson trial.
And that was a circus in and of itself. Even the judge, in my opinion, spent too much time looking at the cameras, as did defense and prosecution. This is a dangerous, dangerous area to get into. I was a prosecutor for 18 years and a rule of law person. And the last thing we need is speculation that, well, nothing will happen. What if something happens?
But that in itself is speculation. I think, in terms of...
It's not a speculation as to whether a person's going to be executed, whether a victim or a victim's family is going to seek to receive justice. I have no problem at the appellate level. But going into the courtroom is it's just another entertainment to be turned into a circus, as we see now, particularly with video cameras, people with their cell phones. We're treading on dangerous, dangerous area here as far as rights are concerned and the rule of law. I'll let you respond.
I understand and respect your opinion. I think when you were talking about a child or a reluctant witness, once again, the trial court can decide whether or not...
So who makes this determination? Every single judge? Who makes the determination? A panel of judges? You three? Us in Congress? Who sits down and determines what the guidelines are?
I think that each judge that is presiding over that courtroom, just like they have to make rulings.
So we have numerous, multiple decisions made as to whether there'll be a camera there or whether there will not be a camera there, and nothing consistent. I think you understand my position on this, and I yield back the remainder of my time.
Can I, would you yield to me?
Certainly.
I want to follow up on his question. In a criminal trial, you have somebody who's innocent till proven guilty. If you stream live even their testimony or their face, are you or are you not, in fact, making a public characterization? And is that something that's, and I know they do it in state court, is that something that we must do, or is it something we'd like to do? And I think that's where the gentleman from Pennsylvania's question goes, where he looks at appellate and says, we could be on board because we don't have this question of innocent people, whether they're witnesses, plaintiffs, defendants. So I would follow up and just ask, is this something that would be nice to do, that you'd like to do, or in fact, is getting the appellate made universally available, including the Supreme Court, more likely to be something where the American people have a right to know and there's less conflict involved?
I would be happy to start anywhere. And if it's at the appellate level, I think there should be a rebuttable presumption that the courtrooms are open and open to cameras. And then if there is something that can refute that for whatever reason at either the appellate level, the Supreme Court, or a trial court level, then that can be dealt with. But that's just something that I think the public has a right to see. We've all, I think, are in agreement that courtrooms are open to the public, and kind of blaming the camera for the circus-like atmosphere that goes on sometimes inside and sometimes outside the courtroom, I think is shooting the messenger. The example that I would use at a federal level is during the trial of the Oklahoma City bomber. There were cameras in the courtroom that were used to broadcast closed-circuit TV so that the people back home where the bombing took place could watch that. And unfortunately, the public missed an opportunity to see a well-conducted trial by Judge Maitch there versus the circus that we saw in OJ.
I appreciate that. We now go to the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman, for holding this hearing, and thank you, gentlemen, for being here today to testify. Mr. Ostriker, in Professor Jay's remarks, his written remarks, and also his testimony, he lays out the principle that federal judges derive their legitimacy from the respect that they command as a result of their personal competence, impartiality, independence, and integrity. Do you agree with that statement?
I do.
And how about you, Professor Bruce?
Yes, I do.
And to maintain that respect that they command as a result of the perception of competence, impartiality, independence, and integrity, judges should make decisions according to the law, unclouded by personal bias or conflicts of interest. That's another statement that Professor Jay makes in his written testimony. Do you both agree with that as well, Professor Bruce and Mr. Ostriker?
I do.
Yes, I do.
And do you also agree that when the public perceives a lack of competence, impartiality, or bias in favor of one party against the other, then the integrity of the judicial branch is undermined?
Of course.
Yes, but that's a more subjective view, depending on your point of view, then.
Well, but judges should strive to avoid an appearance that they might be biased in favor of one party.
Absolutely.
And this is the reason why judges, federal judges, are bound by the Code of Conduct for United States judges. Excuse me, for United States judges, correct?
Yes.
Is to protect those ideals and to ensure that that they abide by those ideals. And but it's troubling that U.S. Supreme Court justices are not bound by that code of conduct for United States judges. Do you have the same bad feeling about that I and Professor Jay have, Mr. Ostraker?
I think that it should apply across the board to all the judges.
You, Professor Bruce?
For what the opinion of a computer scientist is worth, yes, I do.
Well, tell me, is there any reason why there is some uniqueness of United States Supreme Court justices that would exempt them from some code of ethics or code of conduct? And you've already answered that question, so let me ask this. Professor Jay, is there any reason, is there any constitutional basis that would prevent Congress from imposing upon the U.S. Supreme Court justices a rule that they abide by the code of conduct for United States judges, or that they write a code of conduct for themselves and abide by it?
Steve Gillers and I are both of the opinion that the necessary and proper clause, coupled with the power to regulate the appellate jurisdiction of the Supreme Court, gives this body the power to insist on a code of conduct. I think for those of us who are originalists, I think it's useful to know that the original Congress was happy to identify how many judges there would have to be on the Supreme Court, when they would sit, where they would sit. It made them get on horseback and run around the country. And so against the backdrop of those early regulations, the idea that you would simply say, look, we want to make sure that our judiciary ascribes to, that as a condition of the appellate process, that our judges subscribe to basic ethical principles, strikes me as being within the zone. I'm not sure, there might be a counter, there may well be others who disagree, but I think that there is congressional power for that.
Thank you. Mr. Ostraker, do you agree with that?
Yeah, I absolutely do. I think that, unfortunately, I believe what we're seeing now is the Supreme Court promulgates its own rules. So that, I think, would be the explanation for why they don't have rules that are in line with the other justices.
Well, I'm sure that justices, unlike judges, want to be judges of their own cases. And I think that whenever you have a justice that is solely responsible for judging an issue of recusal, then it diminishes the respect that people have for the court's perception of abiding by the law and being unbiased, impartial, and all the rest. And with that, I will yield back. Thank you.
I thank the gentleman. We now go to the gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman. I'm pleased to be joining this subcommittee and look forward to talking about this issue and many other issues about the federal judiciary. Mr. Osterreicher, I have a quick question. I appreciated your approach to transparency in the courtroom and the role that cameras and live streaming can play. I was actually a criminal defense attorney, and I practiced in federal courts. I was also a law clerk in the federal courts in Idaho. And I'm ambivalent and a little bit conflicted about having cameras, because I do see, you just gave the example of the O.J. Simpson trial, and then you mentioned how unfortunate it was that another trial didn't have cameras because of how well it was conducted. But then that begs the question, was it properly conducted because there were no cameras?
No, there were cameras. They just were closed-circuit cameras.
Correct, because they knew that they weren't, it wasn't a nationally televised circus that they were presiding over. So that's the question that, and I'm not taking a position, that's the conflict that I have, because I have seen how it has had a deleterious effect on some trials, and I think the justice was not served in some of those trials.
I think that, unfortunately, that atmosphere in the O.J. trial would have gone on with or without cameras. There was a whole lot more circus going on outside the courtroom when all the parties went through the gauntlet of the media that was outside. I think, once again, it really shows that if the public, and for example, the civil trial that followed, regarding Mr. Simpson. Again, there were cameras there. It was broadcast, and people got to watch that trial. There wasn't a whole lot of commenting going on, a whole lot of spin as to what happened or what you just saw. I think that we need to give the public credit, just as we have for them listening to the oral arguments the other day in the Ninth Circuit, to be able to see and hear for themselves what went on, and that will also...
And I don't disagree with that. I think I have no problem with the oral argument in the Ninth Circuit. I actually enjoyed listening to it myself. Do you believe that cameras should be allowed in all types of trial court proceedings, including criminal matters and preliminary matters addressed without a jury present?
I do, once again, within the discretion of the presiding judge.
How do you answer the concerns of those that suggest that broadcasting trials will have a chilling effect on whistleblowers and other possibly reluctant witnesses?
Once again, I would say this has been unfounded speculation for, scores of years already, and there's really no proof of that. In the New York 10-year experiment, they did 4 different studies where they asked judges, parties, witnesses, prosecutors, lawyers to fill out forms, and both the empirical and anecdotal data show exactly the opposite happened where cameras were in the courtroom.
Professor Jay, do you believe that the grounds for disqualification are well stated in the statute?
Pretty well, yeah. They're mostly uniform across the country at this point.
To what extent, if any, have you seen or learned of attorneys using these sections of law to shop for more favorable judges?
It happens, but it is a very risky gambit. In other words, I think the opposite is almost more likely the case. In other words, lawyers think long and hard before they're going to show up in front of a judge and point a finger in his face and say, you're too biased to sit, because more likely than not, the judge will say no, and then they're going to have the case heard by a pissed-off judge.
So, hypothetically, should a judge's political leaning or proclivity for or against a certain political position be sufficient ground for disqualification?
No.
Your testimony recounts the procedural hurdles and resulting issues with employing Section 144. Can Congress amend 144 so that attorneys could conceivably use it as a method for moving for disqualification of a judge?
They could.
How?
How could they do it?
Yeah.
I mean, I think that I would recommend...
What changes do you suggest?
Well, I mean, I think that I would borrow changes that are made in Alaska and in Montana. Both have statutes which essentially allow for substitution of judges. It's a one-time only arrangement in which a party can request a different judge without making the allegation that the judge was biased. And it's judge shopping. But it's a one-shot deal, and the word that I received when I was working this issue was that it cut way back on disqualification for cause later. So, and the people who use it like it. The people that don't resent it. The people who don't use it sort of worry that it creates this judge shopping thing. But the people who use it say, well, if that's one way to preserve public confidence in the courts by a one-shot only deal, it'll work.
Thank you. I yield back my time.
Did you mention also California has that?
California, about 20 jurisdictions do, and most of them are in the West, and most of the ones that use it are okay with it. Not all, but I mean, I think I've heard some judges complain, but it's the ones that don't use it that find it difficult to fathom.
Thank you. We now go to the gentleman from Florida, Mr. Deutsch.
Thank you, Mr. Chairman. Mr. Chairman, I have very mixed feelings about today's hearing. On the one hand, I agree.
About the hearing or the subject matter?
About the hearing and the subject matter. I do agree that there's a lot that can be done and needs to be done to improve public access to the PACER service. As someone who has personally had the joy of muddling through PACER, I can see what a difference improvement would make, and I'm glad we're having the opportunity to talk about that. Similarly, revisions to federal court policy on cameras are long overdue as well. Policies prohibiting cameras in the courtrooms impose severe limitations on the public's ability to observe court proceedings, interpreting laws that can impact the daily activities of every American. These restrictive broadcasting policies shroud the Supreme Court and federal court proceedings in secrecy and raise questions in the minds of the public on the administration of justice. I mean, you can walk into any state or federal courtroom in America and see rows of benches or seats to accommodate public audiences interested in watching legal proceedings. The U.S. Supreme Court also has public seating available to accommodate the lucky few. Courtroom seating for audiences recognizes and accommodates our nation's long tradition of public court watching. The U.S. Supreme Court and our federal courts hear and consider some of the most important issues facing our country. The proceedings and the decisions issued from the proceedings by the Supreme Court and federal courts impact every facet of the lives of Americans. The Supreme Court and the federal courts need to recognize and adapt to these changes to permit the next generation of court watchers access to proceedings on important legal issues. Such changes should include permitting television broadcasting. I've long supported the efforts of Mr. King, Mr. Nadler, and others in trying to open our nation's courts to public access through cameras with appropriate protections for the parties and judicial discretion over sensitive matters. It's time that the Supreme Court and federal courts' practice is changed. But I cannot help feeling the twinge of regret at the focus this week on judicial transparency and ethics when the executive branch has such glaring problems with both. It doesn't take a constitutional law scholar to see that President Trump should not continue to have an ownership stake in the company that bears his name. His family's operation of the Trump Organization has already given foreign governments the opportunity to funnel improper payments through Trump hotels and golf courses and rental properties to curry favor with the administration with no accountability to the American people. The complete inadequacy of President Trump's approach to conflicts begs us here, the House Judiciary Committee, to investigate ethics violations of the president and his nominees. His choice to violate the Constitution and his complete disregard for the well-established norms followed by previous administrations expose our democracy to potential foreign influence and to the risk that he will use the power of his office to divert the public good for his own private benefit. These, Mr. Chairman, I would respectfully suggest, are the most pressing issues of transparency and ethics facing our country today. But since executive transparency and ethics falls outside the jurisdiction of the Subcommittee on the Courts, Intellectual Property, and the Internet, and since this committee as a whole seems fiercely determined to ignore our executive oversight responsibilities in the face of unprecedented threats by the Trump administration, I suppose that judicial transparency is the most we can hope for, and I'm grateful for our witnesses for sharing their thoughts on this important topic today. With that, I yield back.
Gentleman yields back. With that, we go to the gentleman from Texas, Mr. Poe.
Thank the chairman. Thank you all for being here. During my other life, I was a trial judge in Texas for 22 years. I tried only felony cases, everything from stealing to killing and everything in between. And I was one of the first, if not the first, trial judge in Texas to allow cameras in the courtroom. We had a very structured system where it was very discreet. The jury never saw the camera. The camera did not film the jury, did not film child witnesses, sexual assault witnesses, or any other witness that the lawyers did not agree should be filmed. Those that opposed that system, said the world would end if we had cameras in the courtroom. Lawyers would play to the cameras and all of those things that, no offense to the academics, but the academics were opposed to it because they had never been in a courtroom and never had tried a case in their life from either point of view. But none of that happened. Lawyers don't play to the cameras. They play to the trier of fact, whether it's the court or the jury. And we tried very serious cases, including death penalty cases, and we allowed cameras to film those cases. And it worked, and it was great for not just the public, but for law students in their universities to see those cases tried from gavel to gavel. And I'm a great fan of that because we have the greatest judicial system in the world for determining guilt or innocence. No, it's not perfect, but it is the absolute best that anybody has ever come up with. And why would we not want the world to see it? And the public is stuck with a 90-second soundbite on the news by what some reporter thinks took place in the courtroom that day, whether it's in a trial court or whether it's in the Supreme Court or an appellate court or a federal district court, because they are not permitted to see what took place in that courtroom. And I think it is shameful that the public cannot see that. So I am absolutely in favor of cameras in the courtroom, co-sponsoring with Mr. Conley a bill that would allow cameras in the Supreme Court unless the court decides due process would be violated. There are other bills. Mr. Nadler has a bill that's even more progressive, if I can use that word, than, it's all right with you, Mr. Nadler, than just the Supreme Court, to let federal courts be open. I think the recent case of the that was in Seattle before a federal court would have been a perfect example of allowing that case to be heard with a camera in the courtroom and let the public see for themselves without having to rely on the news media's 90-second soundbite as to what took place in that courtroom.
Would the gentleman yield?
Yes.
Judge, I appreciate your thoughts and personal experience on this. Could you share what you did in the courtroom to protect if there was a sexual assault victim or a victim who had been threatened by the defense? And because I share a lot of your beliefs here, but was wondering what you did in your personal experience presiding over the court to protect those victims.
If there was I'll reclaim my time, if there was a sexual assault victim, that victim was not televised in the courtroom. That was the rule. The sexual assault victim was never televised, and only the audio sometimes was allowed, but only by agreement of the prosecutor and the victim, and of course the defense attorney. But the video was never televised in those cases. And child witnesses, the same was true with a child witness. Never a child witness, even if it was not the witness was not a victim. The child witness was never televised as well. And so we had certain rules, and the media abided by those rules. We never had a problem with the media violating the rules. They knew there were consequences. They might be in jail if they violated the rules. We never had a problem with it. So it worked out very well. We went through all of the so-called problems, and I was impressed, really, how smoothly all of that worked. So,
Mr. Chairman, by unanimous consent, I'd ask that the gentleman be granted an additional minute to conclude his remarks.
Without objection.
I thank the chairman. Anyway, I will get to a question in a minute, in less than a minute. So it's just, I think, in this day and time has been said by many people that we show the world that the most important court in the world, the Supreme Court of the United States, where you can go and sit, but you can't sit but 15 minutes till they kick you out and bring in another bunch of folks, because that's their rule over there. You can't watch the whole trial unless you're on this side of the bar. That they get to see everything that takes place in the Supreme Court. I think it would be of tremendous benefit to law students to see that, and to lawyers, God bless them, let them see what takes place before the Supreme Court, and of course the public as well. Mr. Osterreicher, would you agree with that scenario or not?
Oh, I would absolutely agree. I commend you for your progressive attitude. I'm admitted to the Supreme Court. We have filed amicus briefs in a number of cases. I've appeared for oral arguments in those cases, and I just sit there and shake my head at the fact that there's only about 300 people in that room that get to see what goes on in that courtroom. We're seeing people, pay for, a lot of money for somebody to hold their place to get a spot in. But in terms of the snippets, that's the other thing that was always a contention. Well, you're only going to show a small part of the trial or a 15-second soundbite. The fact is that nowadays, with live streaming, with the fact that not only live streaming on the internet, but by broadcast websites, by print websites, you can have the public be able to see the whole trial for themselves. Yes, we'll still be relegated to a small part on the news, but right now the public has no other opportunity to see what goes on in the courtroom other than that snippet where cameras are allowed. In this case, with live streaming, I think that will be available for everybody to either watch live or watch later.
I thank the chairman for the extra time.
You can thank Mr. Johnson. Thank you. The gentleman yields back. We now go to the gentleman from New York, Mr. Jeffries.
I thank the chairman for yielding and for convening us here today. Thank the panel for the information that you've presented, for your expertise, for your presence here today. This certainly is an otherwise important topic, although I would suggest that the timing of this hearing is a bit perplexing. There is a swamp of corruption that's percolating at 1600 Pennsylvania Avenue. The National Security Advisor has resigned in disgrace. Our national security has been placed in jeopardy as a result of the Trump administration continuing to play footsie with Vladimir Putin and the Russians. It's impossible to figure out where the Trump family business ends and the White House begins. The president himself is a living, breathing conflict of interest. 17 different intelligence agencies have concluded that the Russians interfered with our election in order to help Donald Trump, and yet we're here today talking about the PACER system. Just seems to me that there are more pressing issues related to the existential threat that this administration presents to our democracy that we could be spending our time on. Now, we have a president who is in the illegitimacy business. He peddles illegitimacy with all the viciousness of a street corner dealer. He spent 5 years perpetrating the racist lie that Barack Obama was not born in the United States of America, trying to undermine the legitimacy of a duly elected and re-elected president. He regularly attacks the legitimacy of the news media, the so-called Fourth Estate, which is essential to the constitutional fabric of our democracy. It's why we have a First Amendment. He has questioned the legitimacy of the intelligence agencies that now report to him. I wonder why. And he's also gone after the legitimacy of the judiciary. And so, to the extent we've got the expertise available on this panel to deal with that issue, Professor Jay, let me ask a question. You state that the survival of our courts depends upon the perceived legitimacy with the people in this country that they serve. Is that correct?
Yes.
And is that largely because members of the judiciary are appointed and they're not elected, and therefore they derive any respect and legitimacy that they have from the factors that you've set forth as it relates to their competence, integrity, and independence?
In part. I mean, part of it also is that every branch of government really does have the power to bring the other branches of government to their knees unless they believe in it. And to the extent we lose faith in the judiciary, it basically creates, there's no incentive not to abuse the other branches. And so part of it is that the judiciary is uniquely vulnerable because they aren't elected and don't have that reservoir of legitimacy from the electorate. But the other part of it is that in the absence of that legitimacy, the president and the Congress both can essentially delegitimize the judiciary themselves.
Now, Donald Trump recently attacked a member of the Article III Judiciary as a so-called judge. Is that correct?
Correct.
What exactly is a so-called judge in your view?
Well, The reason I look at that as different than just robust criticism, it implies that this is not a judge at all. This is someone masquerading as a judge who is undeserving of our respect. And when you combine that with the statement later that if they want our respect, they will simply do what we want them to do, that tells me that I don't want an independent branch of government. I want someone who will simply do my wishes. And that worries me. That to me delegitimizes the judiciary as a separate and independent branch of government.
It's amazing to me that we have a president who was helped by the Russians in terms of his election. The FBI director interfered in an unprecedented fashion. He benefited from the fake news industry throughout the election. He didn't win the popular vote. He lost the popular vote. A majority of Americans didn't vote for him. They voted against him. His administration is now shrouded in scandal, and he calls an Article III member of the Judiciary a so-called judge. It's shameless, and this committee needs to do something about these independent attacks on the judiciary. I yield back.
If the gentleman would yield.
Certainly.
I'm going to associate myself with one part of what you just said, and that is that I don't believe we should ever use terms about judges that question their competence or integrity on this committee unless we have a reason or anywhere else. I will say that perhaps we all should entertain not delegitimizing the other branches except where we have a specific claim and in that venue. But I do want to share with my appreciation that we do need to all raise the standard of how we deal with the court, how we refer to differences in how we believe something should have been decided or how they believe it. And I want to share that because I think that, although I didn't necessarily associate with everything you said, I think it's important that this committee, as we look at judicial responsibility, that we not disparage the court, which, as you say, has generally done an extremely good job of delivering honest representation through the federal court system. I thank you.
Thank the chairman for his remarks.
Thank you. We now go to Mr. Biggs, who's been patiently waiting, and I want to apologize to you. I got a mixed signal, so you actually should have been before Mr. Poe, but I'm sure he appreciates your indulgence. Thank you.
Thanks, Mr. Chairman, and Mr. Poe can go before me anytime he wants, and I appreciate the subject of the hearing today, and I appreciate those who are here on this panel testifying today. I appreciate you being here. You know, what I find interesting is that tensions actually between the three separate branches of our government are nothing new. Indeed, they've been present in America since its inception. In fact, the very famous first case that laid the foundation for judicial review, Marbury versus Madison, arose specifically because of that tension between the executive branch and the judicial branch at that time. So I think it's interesting to hear folks be critical of the current executive because of comments that he may have made with regard to a separate co-equal branch of government. But it's not new, these types of discussions, whether it be Andrew Jackson or Thomas Jefferson or FDR's idea of packing a court, increasing the number of justices so you could get a desired outcome. This kind of tension is not new. It is as old as the Republic is.
Would the gentleman yield?
I haven't finished my statement yet. I'd like to finish my statement.
Would you yield after?
I'm not yielding yet, so hold your question. Additionally, when we look at the Article III branch of this, particularly the federal judges here that we're talking about, many refer to them as being lifetime appointments, but in fact that is only the de facto arrangement that has emerged and evolved over time. The actual language of Article III, Section 1 says that they will hold their offices during good behavior. And so really what we're talking about today when I hear the testimony, and I appreciate it because we're talking really, in my opinion, about transparency and having practiced law and having tried many cases, there is a certain mystery that kind of shrouds what goes on in the courts, and whether it's the broadcasting of court cases, whether it is the idea of of making the PACER system more accessible to the public, or whether we're talking about the ethical determination and processes within the courts themselves. I think those are really important issues to be sitting and discussing today, and that's why I'm so grateful that you're here, and grateful for the chairman for organizing and conducting this committee hearing today. So my question would be for Professor Jay is, as we look at this, what do you see are the real checks for the legislative branch on the judicial branch?
The checks include the 100-ton gun, as it's so called, is impeachment. You do have a check. You control the judiciary's budget. You control the lower court's jurisdiction. You are enabled, by virtue of the fact that you have the discretion to establish courts, that implies a lot of regulatory authority over things like a disciplinary process. And so because you can theoretically disestablish courts, you can regulate them in between. And so there are all kinds of powers that can be used. And getting back to the point you made before, I think it's an important point to recognize that there's very little new under the sun. But it's also true that we have constitutional crises every now and then. That's not precedent for it being a good thing. It's just a precedent for it happening. And one of the great things about our system of democracy, I think, is that we know when to hold them and when to fold them. We know when to stay our hand and when to get aggressive. And I think that having all of these powers used wisely has kept us going as long as it has.
Thank you, thank you, Professor Jay. And I agree with you that there are a series of checks that the legislative branch has, and I'm not sure that we exercise those too often, but I think the discussion today with regard to disciplinary process that needs to be put in place, and maybe we discuss that with the U.S. Supreme Court itself, I think that is integral to exercising the Article I powers, the checks against the courts itself.
That's a fair point. Certainly the inquiry is a fair one, yes.
Then, Mike, so in line with that, when we start looking at transparency, and I think I'm just about out of time, but Mr. Osterreicher, I was going to ask you, I want to know how we get access to the broadcast, and if that, in the 10-year study in New York, how is that made available? Because it seems to me that as you're broadcasting, you are creating a separate record that is going to be relevant to any kind of appellate procedures when you're videotaping and recording lower court proceedings.
Well, I think right now what we're seeing, at least at the federal level during the pilots, is that they were operating the equipment rather than the media. So that becomes part of in the Ninth Circuit, they have their own YouTube site. I would have assumed that they are retaining those records as public records. During the 87 to 97 10-year experiment, it was prior to live streaming, and really the only time you would get anything was that broadcast, unless you were actually recording videotape of it as well for later broadcast.
Thank you, Mr. Chairman.
I thank the gentleman. We now go to the also very patient Mr. Swalwell of California.
Thank you, Chairman, for holding this important hearing. And I will go back to the gentleman, Mr. Biggs, and ask, and I would yield to him, do you agree with Judge Gorsuch that it was demoralizing for President Trump to call the judge in Washington a so-called judge?
Mr. Chairman, I'll take the time. Thank you so much for yielding time to me. On that specific issue, I don't know what, apparently Judge Gorsuch was demoralized. I don't know who else might have been demoralized. I don't know anybody else who might have been demoralized when members of Congress say this president's
Well, I'll reclaim my time,
president.
and I'll ask again, do you believe that it's demoralizing to call a judge a so-called judge? And I'll yield to the gentleman.
Thank you. And hearkening back to my trial court days, I'd say I'm not sure that that's relevant to anything, what I specifically think on this, but you're asking a really broad question, and so I'll tell you that I think that there are probably some judges that are more sensitive than others.
I'll reclaim my time.
Some
I
may
appreciate
be
it.
demoralized and some may not be. I don't know.
I was a trial court prosecutor, and I look forward to working with the gentleman. on this issue, but I guess I'll ask Mr. Jay, you said we believe in the tripartite system of government that our founders framed. We believe in the checks and balances that systems provide and the role that a strong, separate, and independent judiciary plays in keeping the executive and legislative branch in check. So I guess I'd ask each person, do you believe that calling a federal district court judge a so-called judge is respectful or disrespectful? Mr. Ostreicher.
I'm not sure that I'm going to be the one qualified for this. The only analogy I will draw is this weekend I judged a moot court contest for law students. I was the presiding judge. I called myself the so-called judge only because I wasn't one. So I think using that reference to an actual judge certainly calls into question why one would do that.
Sure. Mr. Bruce, respectful or disrespectful?
I would consider it, again, for what the opinion of a computer scientist is worth, I would consider it disrespectful.
Thank you. And Mr. Jay,
my testimony would suggest, yeah, I don't think it's respectful.
Yeah, and how about your home state judge, Judge Curiel, being referred to as not being able to be impartial because of being a Mexican-American?
Yeah, he's actually an alum of our law school as well. My concern there is, I mean, to be clear, I'm less concerned about whether you're respectful than I am whether you are attacking the integrity of the court itself. And when you are implying that someone is incapable of rendering impartial justice because of the color of their skin, I think you've got trouble. That's more than disrespectful. And I think similarly, calling someone so-called I mean, it's a snippet, it's a tweet, but it's what we have to work with. And so it's trouble. I'm not going to go so far as to say it's the end of the world, but it is indicative of a larger problem that attacks the legitimacy of the court, and that's what worries me.
Thank you. And I want to go to the purpose, one of the purposes of the hearing. And after practicing in a trial court for 7 years, I've given a lot of thought to the O.J. trial. I was 13 years old as I watched that unfold, and just like most of America could not believe that he was acquitted, but as time passed by and as I spent time in a courtroom and I've watched the recent documentaries, Mr. Ostreicher, do you think that, and this is quite a existential question, I guess, but do you think that had there been cameras on the streets for the police officers of Los Angeles in the years leading up to the O.J. trial, do you think that would have actually been more informative and that would have held them to account rather than folks blaming the cameras in the courtroom as being the reason that he was acquitted? Do you understand the question?
I'm not quite sure I do.
If the police officers had body cameras and there was more transparency on those officers at that time, do you think that may have been more helpful and brought them into account? Because it seems to me that it wasn't the cameras in the courtroom that poisoned the jury, that it was really that there weren't cameras in the streets and that police officers in Los Angeles weren't being held accountable and their credibility was devastated.
I think it may, but the fact was that most of the officers that responded to that crime scene were detectives, and at least as we see it now, only patrol officers are wearing body cams. So I think even if the program was fully implemented, I highly doubt that those detectives would be wearing body cams. But certainly it would have helped to see who went where and did what with evidence collection.
Sure. Thank you. I yield
Would the gentleman yield?
Yes.
I want to engage in a quick colloquy because do you think that perhaps politicians have gotten in a habit that extends between each other and then, flows over into Article 3? You weren't here, but when I came to Congress, it was popular for many people to say that President Bush was an appointed, not a elected president. Many people didn't come to his inauguration for that reason. Obviously, here today, we had a member on the dais cite delegitimizing President Trump because he didn't win a majority and because of, quote, Russian getting him the election. Is it perhaps just a spillover, and is it something that all of us, executive branch and here in the House and Senate, need to get out of the habit of delegitimizing ourselves and thus spilling over into Article 3. Just wondered if you thought about that.
Reclaiming my time and appreciate the question. I guess the prosecutor in me says, just stick to the evidence. If you follow the evidence, you'll find the truth. Yield back.
The gentleman ends with a good yield back. We now go to the gentlelady from California, Ms. Lofgren.
Thank you, Mr. Chairman. I actually agree that it seems a little out of body to be discussing the PACER system when the National Security Advisor resigned and people are questioning what did the president know and when did he know it. But that's what we're doing here, and so that's what I would like to pursue, which is the PACER system. Professor Bruce, 10 years ago, there was a pretty comprehensive privacy audit that academics performed on the PACER system, and they found that there were Social Security numbers included in the records. The audits were sent to the 31 district courts, administrative office of the courts, the Judicial Conference, and the like. However, it's my understanding that despite those findings, you still have Social Security numbers scattered throughout the PACER system. The technology of the system is a little bit bulky, and I'm wondering if you have observations on what steps could be taken to redact sensitive information in the system, or whether we might be well advised to take up some of the private sector offers to take the data and maybe use better technology, and as a condition of doing that and providing it for free to the public, to redact sensitive information.
Let me make 4 points actually around the whole privacy issue. This is one of the places that has suffered the most from the inability to do comprehensive research across the entire system. If there were bulk access to the data, you would certainly have a lot better eyes on what was going on there. Secondly, just as with the problems of privacy that surround cameras in the courts, this is a problem that's unevenly distributed across the courts, so it's sort of hard to know where to look. We know from experience that a lot of this stuff can be very easily dealt with in software. It's been done in other jurisdictions. Mostly on something like Social Security numbers, that's going to be an easy problem to solve because they're very easy to identify. There are harder problems, and some that are completely insoluble, as for example, when you have a victim of domestic violence named as a 39-year-old school teacher from Gordon, Nebraska, where there is maybe one 39-year-old school teacher. That you're never going to get rid of. In smaller jurisdictions, in Canada and Australia, this has been done successfully with automation, or more accurately, automated support for some editorial redaction for a considerable period of time, at least 10 years or 15 in the case of Canada, a shorter time in Australia. Should we take outside private offers to do that? Yes, if they've got the technology, absolutely.
Let me ask you something that's always bothered me. You can get some documents for free, but you have to create an account, and the account actually asks for your full name, your address, your phone number, your email address, your date of birth. It seems to me rather intrusive to have to provide all that information to get access to data that really the public should have.
That seems intrusive to me too.
I think, what I'm interested in, Mr. Chairman, from this hearing is what steps we might take to recommend changes in this system. First, I don't think we're ever going to get the technology upgrades we want in the current system. I think we ought to aggressively and systematically pursue private sector options that would allow free access to this data that is not, that provides adequate privacy protections for individuals whose presence is revealed in the documents, and that provides it on a basis that is not intrusive to the public, that should have every right to see this information.
If I may, this circles back a bit to the question that Mr. Nadler asked me earlier. If you look at the 2015 report from the AO on the development of the next-gen system. It was actually a journal article that was published by the two senior designers. It's very clear from that that very, very little consideration was given to really any outside source of information beyond the judges who were serving on the sort of immediate customer committee. And that in fact, the AO completely dismissed the recommendations of MITRE Corporation, which is a very well-respected consulting group for this kind of judicial administration. So I don't think, I agree with you, I don't think we can expect a great deal of receptivity from the AO.
Well, I would just say I respect the judges for their insight into the law more than I respect the judges for their technology expertise, and I would yield back.
Mr. Chairman.
Yes, for what purpose does the gentleman seek recognition?
Mr. Chairman, I ask unanimous consent that the gentlelady from Texas, who is a member of the full committee but not of the subcommittee, be permitted to ask questions.
Without objection, so ordered. The gentlelady from Texas is recognized.
Let me thank the ranking member and the chairman for their extended courtesies for a very important hearing, and thank you, gentlemen, for your testimony, but also for your advocacy. I am going to follow a certain line of questioning, but let me give a preference or a premise upon which it is based. I happen to be a member of the bar. Sometimes we humorously ask which one, but I am a member of the bar. And came through law school at the time that this was of great high honor, and the whole idea of the sanctity of the Constitution and the strength of the Constitution was very much enshrined, if you will, in our law school, but more importantly, it was a document that we held with the highest of esteem, and thought as we graduated we were going to be the advocates, the single sponsors of the value of the Constitution to the American public or to our immediate constituencies. And at that time, we were not elected persons, but just those who had graduated from law school. With that in mind, Professor Jai, I would like to go on a line of questioning that the other gentleman may comment on, but I know that the issues that they are advocating I am very much familiar with and believe in their advocacy. The good news about what has happened over the last couple of weeks has been the increase by the American public of understanding civics, understanding their government, understanding what roles their government plays. And I've enjoyed speaking about the three branches of government, the judiciary, the legislature, and the executive, which by the Constitution, three equal branches of government. I love saying that. We saw one episode with President Nixon and the Saturday Night Massacre and Elliot Richardson deciding to go a different way, then Attorney General of the United States. So because the American public's eyes are on all of us, I think it's important in as much as we can to be on our best behavior, but also to share with them some of the responsibilities that we have as a legislature, judiciary, and of course the executive. So I'd be interested, I'm starting first with Mr. Miller's comments that were made over the weekend, Steve Miller, who indicated the executive power is all one, singular, and without any possibility of oversight or questioning. I think many of us took a step back, step to the side, and were either aghast or were trying to struggle with the Constitution or court precedent to find out what the basis of that was. I'd appreciate your comment on that. I'd also appreciate the fact that the judiciary likewise does not have the authority to reach beyond its boundaries, to rule in a way that would skew the rights of the American people. They interpret the law. And so I would love for you to, with this whole concept of transparency, but also the judicial ethics as well, give the boundaries of the judiciary, and I'm obviously speaking about the federal judiciary. And then I'd appreciate as well that if American people, the American people, probably have not paid attention to the judiciary except for, let me not suggest that they are not engaged, but I was a judge in the municipal court, so except for they're coming before municipal judges dealing with their citations, or they may be in court for their own personal matters, now we've opened the door for them to appreciate the value of this nation. What happens to their attitude about the courts and judges. If, and I'm sure some of my colleagues have raised this, it's so-called judges, he's a Mexican judge, so he has to be biased. We are held together in this country by our adherence to the principles of our underpinning documents. I yield to you, Mr. Secretary.
This is a teaching moment. I think it is, the events to me have been troubling, but they offer an opportunity to talk to people the way you describe. I think it's important to understand that, earlier, I think it was Mr. Biggs who spoke, or one of you spoke in terms of Marbury versus Madison being the first point at which judicial review was brought into the conversation. But in fact, it predated the formation of the Constitution. The judiciary has long been understood to have these powers to hold the other branches in check through the use of judicial review, through independent assessment of the law. And when a member of the administration stands up and says what the president says goes and implies that its power is absolute, I think it raises a flare for me. Because it suggests that, first of all, that he doesn't understand the way the system works, and that he is counting on people he is talking to not understanding the way the system works, and not understanding that judicial review is not just a bunch of people having second opinions. They have a different role to play. That throughout this conversation about whether the judges overreached in this scenario, I never once heard any discussion of the actual constitutional issues that were in play. This was all about judges overplaying their hand simply because they disagreed with the president. And I think this is a moment for all of us to step up and say, this is how the system works in very simple ways. And an honorable and men and women of integrity have a right have a duty to look at the law and decide how it goes. And you in this room have a right to criticize those decisions and say it's wrong, to be part of this public dialogue. But that stops short of saying, because I disagree with you, you are illegitimate. Because I disagree with you, you are someone who should be ignored or marginalized. And that's what worries me, that line between vigorous disagreement and delegitimization.
Anyone else want to comment? I got a gentleman. Anyone else? All right.
Thank you.
Let me thank you very much. And might I, Mr. Chairman, I'm just finished on this note. This is the body of people that will be dealing with these issues for a period of time. And I think this hearing, and to the ranking member, is a potent hearing. And I hope that as we go forward, we'll understand that protecting these three branches of government is a bipartisan effort, and we should strongly do so, as well as utilize our investigatory powers in ensuring the integrity of all aspects of government. I hope we will be doing that for the American people. I yield back. Thank you.
I thank the gentlelady. I thank you for coming over and participating today. It was a welcome addition. I'm going to try to close. Hopefully I won't open any new wounds as I do it, but Professor Jay, at the end, I detected something that I'd like to not rebut, but to add on to. You talked about the executive branch feeling like in national security, they had such broad powers as to not be questioned. And that's a debate that is not new. I've never seen a president who believed the War Powers Act actually affected them. The moment they get sworn in, it seems like that, even if they were a former member of this body, they move beyond that. So that's not uncommon. But the court, the Ninth Circuit, does seem to have taken what it has been used to, and I live in the Ninth Circuit. It's been used to questioning the process in civil rights cases of what intent is. So if somebody's motives are not pure, then the law, even if perfectly written, is invalid in the Ninth Circuit. They haven't been sustained very often when going to Supreme Court, but they've had that view. And in this case, it appears to me, as a bit of a layperson far removed, that they're doing the same thing, in that they're determining that the president's statements and or motives, in fact, are justification to overturn his ban not on the letter of it, not on the statute, but in fact on his motives. Would you agree that that they have taken that liberty, whether it's theirs or not, but they've certainly indicated it?
I have no opinion on that, but
you don't have an opinion
no,
on what the Ninth Circuit did?
I mean, I have not studied the opinion in detail sufficient to
Have you
draw
heard
that
their
conclusion. But I
word?
don't disagree with you. I don't disagree with you. I'm not challenging it. I'm simply saying that I don't.
Either of you listened to the court review? Because I mean, I certainly heard it pretty loud and clear that they believe that they can judge the intent of the president in crafting something as invalidating it regardless of the words. And I know that's not your subject expertise.
If I may, I mean, at least in my listening to it, I think the court was trying to get evidence. I think they were listening to the government side saying, no, this wasn't our intent, and then they looked towards the president's statements as being evidence of some intent. Whether or not that comes into play, as you said, in terms of the law versus the facts, obviously we will see.
And I do look forward to this, the case going to the court on, to the Supreme Court on that thing. Yes?
Mr. Chairman, to strike the last word, I would simply point out, first of all, that the court, neither Judge Robart nor the Ninth Circuit decided the case. They were ruling on a temporary restraining order, in which you don't go through all the evidence and make determinations, but you do say, well, who has a likelihood of prevailing on the merits, and as a matter of equity, in balancing the equities, who would be harmed if we let it stand or not stand. On that basis, the Ninth Circuit, I think, had ample reason to rule as it did, because there'd been no evidence showing harm if they overthrew it, and plenty of evidence. Obviously, the plaintiffs would be harmed if they didn't, I shouldn't say overthrow it, stay it. And in terms of the constitutionality that you were referring to, they didn't make a finding. They couldn't until after the hearing, but they said there's likelihood of success on the merits, and they did look to intent there, which at this stage of the game, they should.
Well, and I'm not in a position to agree or disagree. I was asking the question because the Ninth Circuit does look to intent. They've even overturned laws that were written in which a witness who came before the body that wrote the law, City Council, the witness said something which they said went to intent. In other words, a tainted witness thus taints the decision of it. And it's in looking at City Council's laws, that may seem fairly benign, but in looking to a president who's entitled to essentially a right to privacy of his thoughts and deliberation and executive power, it will be interesting to see it before the Ninth Circuit. I'd like to quickly close, and I appreciate your input on that, and try to summarize what I think I've heard here today. And Mr. Ostriger, I apologize, I've not gotten your name right once, but I have noticed it's been said several different ways.
Just don't call me late for dinner.
I think the one thing, without calling you late for dinner, is that you got agreement that there has been no showing that convinced anyone here at the dais that there's a reason not to video capture appellate activities broadly, which would potentially include the Supreme Court, but clearly would include all of the circuits. So I think you walked away today making your case for that. Obviously, I think it's fair to say there was less agreement as we got down to witnesses and victims and so on. Professor Bruce, I think you made a compelling case. The only thing that I didn't hear was an oddity that is unique to this member, and that is that we've required the administration under the Data Act to put all information in machine-readable format. And one of the interesting things about PACER is even if they handed you all the information, in order to make it usable to a broad public, it would have to be converted into machine-readable with metadata attached. Isn't that true?
That is true, and frankly, I chose not to approach that issue today because I thought it was a bridge too far. But it is absolutely the case that it would need to be put into XML to be maximally used.
Well, and I waited till the end to cover this because it is my intent to offer legislation that expands the Data Act, which Senator Warner and I were the original authors of, to include the Article 3 with the recognition that they have broad authority. That does not happen to be one that is exclusive to them. And so I will be offering that again with Senator Warner as the Senate companion for just that reason, that the bridge too far is no matter what they do, the information they have is not currently as valuable as it should be.
That's correct. Thank you.
Thank you. And I think when it came to the questions of integrity of the court, although it was there was a considerable discussion about the so-called judge comment, I think you made a compelling case here that it is a fragile court, that even a 140-character statement by one individual who happens to be the President of the United States can have an effect on a court, as can a question of whether this 80-year-old judge is competent, as is this judge biased, as is, does the court system hold its own accountable, as is the question of whether or not there is a recognition of the financial holdings in some format of the of members of the court, as there are in the other two branches. And so I think you made a good case that we will follow up on, that we need to work with the court and or work with our constitutional powers to add those so that no one can second-guess the court in those areas, which I think is a particularly important area, and I think you made a good case on it. I would recognize Mr. Nadler if he had any other closing comments.
No.
Hearing none, I want to thank all of you. We will keep the record open for 5 days. If you have additional comments or thoughts afterwards, we would accept them into the record. And with that, we stand adjourned.